Mabuhay! I am Awal Fajardo from BSHN3A, and today we will discuss the law on partnership and corporation. This presentation will provide a comprehensive guide to business organization in the Philippines, focusing on partnerships and corporations. Before we begin, here are the objectives of this discussion. Understand the different types of partnership and corporations. Identify the legal requirements for forming and managing partnership and corporations. Analyze the advantages and disadvantages of partnership and corporations. Apply the legal principles to real-world scenarios. By the end of this presentation, you will have a clear understanding of how these business structures work and their significance in the business world. To organize our discussion, here is the outline of the topics we will cover. Introduction to business organizations. Partnerships. Definition and essential requisites. Advantages and disadvantages. Classification of partnerships. Forms of partnerships. Obligations of partners. Dissolution of winding up of a partner. Application of law, partnership. For corporation, definition and right of succession, kinds of corporations, advantages and disadvantages of a corporate organization, distinction between partnership and corporation, steps in creating and organizing corporation, steps in corporation, contents of the articles of incorporation, bylaws, liability of the board of directors, dissolution of a corporation, corporate liquidation, application of law, corporation. Government requirements for doing business. Business organizations play a vital role in the economy. In this presentation, we will focus on the two main types, partnerships and corporation. In industries like tourism, strict compliance with legal requirements is essential for business to operate legitimately. For startups, choosing the right business structure is crucial to ensuring stability and growth. Forming a partnership for a corporation is often a strategic decision, especially in competitive industries where legal and financial considerations matter. Now, let's discuss the legal framework that governs partnership and corporation in the Philippines. Partnerships are governed by the Civil Code of the Philippines. This law outlines the formation, obligation, and dissolution of partnerships. Corporations are governed by Batas Pambansa BLG 68, also known as the Corporation Code of the Philippines. This law provides the legal foundation for creating and managing corporations in the country. A partnership is an agreement between two or more persons who contribute money, property, or industry to a business and share profits. To form a valid partnership or relationship, two essential requisites must be met. First, agreement to contribute money, property, or industry. Each partner must bring something into the partnership, which then becomes a common property. Second, intent to divide profits. The business must be established to earn profit, which will be shared among partners. A partnership is not just any association. It must be created with the goal of making a profit. Advantages and disadvantages of forming a partnership. Like any business structure, partnership have advantages and disadvantages. Advantages, easy to form. There are fewer legal formalities compared to corporations. Improved growth possibilities. More partners bring in more resources. Freedom for bureaucracy. Decision making is often more flexible. While the disadvantages are Instability. The partnership may dissolve when a partner leaves. Difficulty in raising large capital. Unlike corporation, partnership rely on individual contribution. Risk of liability. A partner's decision can bind the whole partnership. Difficult to exit. It may be challenging to leave or dissolve the partnership. Classification of partnership. Partnership are classified based on different criteria. According to subject matter, universal partnership, partners contribute all their properties with no specific purpose. Particular partnership formed for a specific business activity. According to liability, there are general partnership. All partners are personally liable for debts. Limited partnership, some partners have limited liability. And according to duration, partnership for a fixed term exists for a specific period of purpose. Partnership at will can dissolve at any time. A partnership can be formed in any manner, but in some cases, registration is required. If real property is involved, a public instrument with an inventory is necessary. Limited partnership require a filing or a certificate with the SEC. Partners have several obligations, including number one, contribution of money or property. Partners must deliver their promised contribution. Contribution of industry. Industrial partners cannot engage in competing business unless allowed. Responsibility between partnership and partner. Partner must act in partnership best interest. Sharing of profits and losses. In the absence of an agreement, partners share profits and losses based on their capital contribution. Property rights of partner. Partnership property cannot be used for personal debts. And lastly, liability of partners to third persons. Partners are responsible for partnership obligations. A partnership can be solved for several reasons, including expiration of the agreed term, mutual agreement of partners, death, insolvency, or incapacity of a partner, violation of legal or contractual terms. After dissolution, the remaining assets are distributed in this order. Payment of partnership debts, return of contribution to limited partners, and distribution of remaining profits to general partners. Let's consider a real-world case. Fernando Sandoval, Naomi Reyes, and Meli Zoyobal formed a lending business. Fernando provided the capital while Naomi and Meli handled collections. Naomi introduced a new partner, Cesar Santos. Later, Meli was expelled for starting a competing business. Legal opinion. Fernando was a capitalist partner. Naomi and Meli were industrial partners. The expulsion of Meli was justified because industrial partners cannot engage in a competing business. A corporation is a business entity created by law with a distinct legal personality separate from its owner. Key characteristic: governed by the Corporation Code of the Philippines, has right of succession, meaning it continues to exist even if stockholders change. Kinds of corporation. Corporations can be classified as stock corporation, divided into shares with the dividends. Non-stock corporation, no dividends, focus on the charitable or civic purpose. De jure corporation, legally formed according to law. De facto corporation has flaws in corporation but operate as a corporation. Public corporation formed by the government. Private corporation formed for private business purpose. Corporation solely used for religious administration. Eleemosynary corporation for charitable purposes. Domestic corporation organized under the Philippine laws. Foreign corporation organized under laws of another country. Now, let's compare partnership and corporations. Number one, creation. A partnership is formed through an agreement between partners, while a corporation is created by law through the Securities and Exchange Commission. Liability. In a partnership, partners are personally liable for debts except limited partners and corporations. Stockholders are liable only up to the amount of their shares. Third, management. Partners directly manage the business unless stated otherwise, while corporations are governed by a board of directors. Judicial personality. A partnership exists upon signing the contract, while a corporation gains legal status only after receiving an incorporation certificate. Number 5, number of members. A partnership requires at least 2 people, while a corporation needs at least 5 incorporators. 6, right of succession. Unlike partnership, corporation have perpetual existence unless dissolved. 7, transfer of interest. Partnership interest cannot be transferred without consent, while corporate shares can be freely sold. Duration. Partnership exists as agreed, while corporations have a 50-year term renewable for another 50 years. Dissolution. A partnership dissolves when partners decide, while a corporation needs state approval to dissolve. Steps in creating and organizing a corporation. Forming a corporation involves 3 main steps. Number 1, promotion. This involves business planning and assembling incorporators. Number 2, incorporation. Filing articles of incorporation with the Securities Exchange Commission. Third, formal organization and business operations. Electing directors, adopting bylaws, and officially starting the business. Steps in incorporation. To incorporate the business, follow these steps. First, draft and execute the articles of incorporation. Second, submit the articles of incorporation to the SEC. And third, pay the required filing and publication fees. Fourth, obtain the certificate of incorporation from the SEC. Once the steps are completed, the corporation becomes a legal entity. Contents of the articles of incorporation. The articles of incorporation include important details such as the corporation's name and purpose, the principal office location, the term of existence, usually 30 years, the names, nationalities, and residences of incorporators and the initial board of directors, the capital stock structure including authorized, subscribed, and paid up capital. Bylaws. A corporation's bylaws set rules and guidelines for its operation. Key sections include stock subscription and transfer policies, meeting rules for stockholders and directors, election and responsibilities of officer, office structure and financial audits, fiscal year and dividend distribution. Bylaws ensure the smooth corporate governance and prevent conflicts. The board of directors exercises corporate power and makes major decisions. However, they can be held liable for mismanagement. If the board mismanaged the corporation, legal actions such as receivership, dissolution, and lawsuits may follow. Solidarity liability. Directors may be personally liable for damages for illegal acts, negligence, or bad faith. Disloyalty. A director must not take advantage of corporate opportunities for personal gain. Trust fund doctrine. A corporation's capital stock serves a fund for creditors ensuring financial responsibility. A corporation can be dissolved in different ways. Voluntary dissolution. If stockholders decide to dissolve, they file a petition with the SEC. Involuntary dissolution. The SEC may dissolve a corporation for the reasons such as fraud, inactivity, or failure to adopt bylaws. Other causes including expiration of term, failure to organize within 2 years, or legislative dissolution. After dissolution, the corporation enters a liquidation period, typically lasting 3 years to settle debts and obligations. A dissolved corporation cannot extend its life through amendments. Stockholders can assign rights to a trustee to handle legal matters. Officers may still be personally liable for unpaid taxes even after liquidation. Let's look at a case study. Alpha Hotel Corporation executed a voting trust agreement transferring shares to the Bank of the Philippines Incorporated due to a loan. According to the Corporation Code, a voting trust agreement removes ownership rights from the original stockholders. Did the board of directors lose their authority? Yes. Are they still liable for the third parties? No. The trustee, Bank of the Philippines Incorporated, is now responsible. To operate legally, business must comply with the government regulations. First, DTI registration for business name and legal documents. Second, business permit. City or municipality requires clearances and fee payments. Third, BIR registration requires a tax identification number, TIN, and registration fees. Fourth is SSS registration requires SSS and PhilHealth numbers for employee benefits. In summary, partnerships and corporations differ in terms of liability, management, and ownership transferability. Forming a corporation requires legal process such as filing articles of the incorporation and bylaws. Dissolution and liquidation follow specific legal guidelines. Business must comply with government requirements for legal operation. Understanding these factors is crucial for success in the tourism and hospitality industry. Consulting legal and financial experts ensure business to operate smoothly. And I think that's it for my presentation. That concludes my presentation. Thank you and have a great day ahead.